Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here to talk about appeals and motions and court hearings that are coming up for Mr. Robert Kelly. There's a whole lot going on, but this is going to be a short video. Let's start with Heather Williams. So you guys remember I did a video about a month ago where the $4 million judgment that was awarded to Heather Williams, well, it was vacated. Jennifer Bongine went in and argued that, they shouldn't have given her that default judgment of $4 million and that the judgment should be vacated. And then I guess they are going to reset everything and then go to trial. And people were saying that, Heather Williams needs to let it go. But of course, Heather Williams has not let it go, okay? So she's still trying to get that $4 million, guys, just so you know. And let me look at her case. So I think it was remember I was telling you guys when they vacated that judgment that there was another case. So she actually had two cases out there. And so one was filed, the one I'm going to talk about now was filed in 2019, but that one where she had that $4 million judgment, I believe that case was filed in 2000. And so this is the original case. And remember I was telling you that she had added Brian Nix and Sony Music to the lawsuit. So this lawsuit has been reopened, or it's continuing. I think it was on pause. But in any event, she is, trying to move forward and trying to get some money anyway, anyhow. And so let's go back to April 17th. There was a response and reply filed. It says comments, defendant Kelly's supplemental opposition to plaintiff's motive for a turnover order of assets. And that was the $4 million that was vacated, and that the Supreme Court of Illinois had said that she would get first dibs. Remember, they didn't say whether or not she was entitled to the $4 million. They were basically just looking at who would get their judgment satisfied first through his royalties, whether it would be Heather Williams or whether it would be Midwest funding, commercial funding. And so that was the only thing that the Supreme Court of Illinois was looking at. So now she's gone back and she filed this motion for a turnover, and then on May 1st, they have a case set on a status call, which was continued. And then again on May 1st, they ruled that a Zoom hearing would be allowed on this case. Then we go on to May 4th. It says that the appellate court mandate is affirmed, and so I'm not sure if they're talking about that the prior, because unless she appealed the decision to toss or vacate the case, with this system that we're allowed to go in and look at these cases, it's kind of hard to tell what they're talking about. So when they say appellate court mandate affirmed, I don't know if they're saying that the appellate court is affirming what the Supreme Court said, because remember, it went to the appellate court and the appellate court ruled in her favor, saying that she did notify Sony first, and then the Midwest funding, I believe it was, took the case to the Supreme Court, and then the Supreme Court upheld what the appellate court stated, that she would get first dibs on this money. And so I believe that's what they're talking about there. And then on May 10th, there is going to be a hearing, and it says open call judicial hearing with Judge Patrick Hennigan. And so that's going to take place at 1 p.m. on May 10th. And they are going to be in courtroom 2503 in the Richard Daley Center. Now, I don't know if people are allowed to go in there, but if you are in Illinois, in Chicago, and you can make it down there to their courthouse, can y'all please see what's going on in courtroom 2503 and then come back to me and let me know what they said. Courtroom 2503 could just be the judge's chambers or something like that, and they may not let people in. But hey, it doesn't hurt to try. So then after the hearing on May 10th, there is another hearing that's going to take place on May 24th. And they says that this is an open call again with Patrick Hennigan, and again in courtroom 2503 at the Daley Center. So that's what's going on with Heather Williams. Now let's go over to Midwest funding, commercial funding. So, and then we're going to go back to April. We're not going to go through all these dates. And let me see. So let's go back to, what did I say, April 17th on that last one with Heather Williams. So let's go to April 20th. So this is Midwest funding, or Midwest commercial funding, and they're suing Mr. Kelly. Remember, they own the building where his studio is. They originally sued him for like $300,000 just so that they could refurbish the building so that they were able to sell it, put it back on the market and sell it, or either lease it out to somebody. And they went in and they garnished like $30,000 from his Chase bank account, but then a judge overturned that and they had to repay the money. So then they sued him for the money. They were only looking for like either $300,000 or $360,000. I can't remember the amount. But then, because, you know, he was going through all his trials and tribulations, that he couldn't appear in court for them, so the judge issued them a $4 million default judgment as well. And so Midwest Commercial and Heather Williams have been fighting, going back and forth on who can get the money first. And like we said, it went to the appellate court, and then it ended up in the Supreme Court. And it was ruled that Heather Williams was the one that legally tendered notice to Sony first. So we're going to go to April 20th. There was an appearance filed and a fee paid. And they were basically responding to the fact that Heather Williams' judgment had been vacated. And their thought process is, okay, well, the judge vacated her judgment. That means that we are the rightful owners to this $4 million, and we can now petition Sony to get this money. But Jennifer Bongine is like, oh no, hold up, not so fast. So then on April 24th, there was a response and reply filed, and it says Defendant Kelly's opposition to adverse claimant Williams' motion for a turnover order, and requests that the court strike the motion where Williams is not a judgment creditor. So they basically want to knock Heather Williams out of the park, and they get this $4 million, okay? So then on April 27th, it says Supreme Court mandate affirmed. And I believe that that's just the filing of where the Supreme Court stated, I guess, that Heather Williams was entitled to this money first. And then on April 28th, there was a strike or vacate an order, which was allowed. And that may have been Jennifer Bongine stepping in saying, hold up, we about to strike you and vacate your order as well. So then on April 28th, the case was remanded, which makes me think that the judge said, okay, I'm going to take a look at this. And then another filing on April 28th, it says notice of motion filed, and it doesn't say who filed that notice. Then again on April 28th, the appellate court mandate was reversed. And once again, it's not telling me who this is for or against, so I don't want to speculate here. And then another motion was filed on April 28th, which says motion for turnover, which means that they are now trying to get that money from Sony, before Heather Williams, now that she's been vacated. Then on April 1st, it says case assigned to Zoom hearing allowed, so that would have taken place already. And then on May 1st, case set on status call to be continued. And May 10th, they are going to be meeting with Judge Hennigan, which is a good sign that it's the same judge for Heather Williams' case and for the Midwest commercial funding. So I think that's a good thing, because we know he vacated the judgment on Heather Williams' part. So Heather Williams has a hearing at 1 p.m. and then he's also going to meet with Midwest funding. So they're all going to be on this call at the same time. Heather Williams and Midwest funding, Jennifer Bongine, and their various attorneys. So now we go to May 15th for Midwest commercial funding, and they are going to have a post-judgment motion that's going to be heard, and that's going to be at 10:30, courtroom 2503 in the Daly Center. And so they are going to go over whatever motion they filed, and like I said, the motion is that they want that money. They want dibs at getting Mr. Kelly's royalties to satisfy their $4 million judgment. And so there you go, guys. The saga continues. At the end of the day, that's what this is all about, is that Heather Williams has not given up. Midwest funding is trying to get that money, get ahead of her in line, and be able to garnish these royalties. And it just will be interesting to see. I'm thinking that since the judge vacated Heather Williams' judgment, he is probably going to do the same for Midwest funding, or he could just take it back to the $300,000 and be like, okay, you're only going to get $300,000 because that's all he owed you. That's all you were seeking in the beginning. Or he could just throw it out altogether, and then they all have to start fresh with a new lawsuit. And so this all has me wondering if Sony is funding all of this. Okay, is Sony slipping Miss Bongine a few dollars to go ahead and take care of this and get this out of the way? So now let's move over to the Northern District of Illinois. Okay, so Jennifer Bongine has filed her motion for an appeal with the one of these circuits. Okay, let me see, because remember, one is the 7th Circuit and one is the 2nd Circuit. Okay, so Chicago or Illinois is the 7th Circuit. So let me go ahead and let you guys know what Ms. Bongine had to say in her motion. So she basically says motion for extension of time to file appellate's opening brief. So appellant Robert S. Kelly, by and through his attorney Jennifer Bongine of the Bongine Law Group, hereby files this motion for an extension of time to file appellate's opening brief. In support thereof, appellant submits the attached declaration and states as follows. So it says, on September 14, 2022, a jury found appellant Robert S. Kelly guilty of counts 1, 2, 3, 9, 10, and 12 of the superseding indictment after a plea of not guilty. Counts 1, 2, and 3 were offenses in violation of Title 18, United States Code Section 2251A, and counts 9, 10, and 12 were offenses in violation of Title 18, United States Code 2422B. The appellant was found not guilty on counts 4 through 8, 11, and 13 of the superseding indictment. 2. On February 16, 2023, the District Court denied appellate's motion for a judgment of acquittal pursuant to Federal Rules of Criminal Procedure 29 and motions for a new trial pursuant to Federal Rules of Criminal Procedures 33. 3. On February 23, 2023, appellant was sentenced to 228 months on counts 1, 2, and 3 to run concurrent to all other counts, and his 30-year sentence in United States versus Kelly in the Eastern District of New York. 12 months on count 1, 2, and 3 to run concurrent to all other counts, but consecutive to his sentence in United States versus Kelly in the Eastern District of New York. 180 months on counts 9 and 12 to run concurrent to all other counts and his sentence in the Eastern District of New York, and 120 months on count 10 to run concurrent to all other counts and this sentence. 4. Judgment was entered on March 5th, 2023. 5. Notice of appeal was timely filed on March 9th, 2023. 6. On March 9, 2023, this court ordered the transcript information sheet to be filed by March 23, 2023, and the opening brief to be filed by April 18, 2023. 7. The docket statement was filed on March 14, 2023. The transcript information sheet was filed on March 22, 2023. With an amended version filed on March 24, 2023. On April 7, 2023, undersigned counsel filed his first motion for an extension of time to file his brief, which was granted the same day. 9. Undersigned counsel received all the transcripts totaling over 4,000 pages on April 14, 2023. 10. Appellate's brief is presently due on May 18, 2023. Appellate is seeking a 45-day extension of time until July 3, 2023 to file his opening brief pursuant to Local Circuit Court 26, where undersigned counsel is unable to adequately consult with her client prior to the current due date, and she is engaged in an exceptional amount of other litigation fully explained in counsel's attached declaration. This is number 12. This is appellate's second request for an extension of time to file his opening brief. 13. The government has no objection to this motion. And then the declaration of Jennifer Bongine. It says, Jennifer Bongine, of full age and having been duly sworn according to law, hereby declares the following. 1. That she's an attorney licensed to practice in the state of Illinois, United States District Court of the Northern District of Illinois and Court of Appeals for the 7th Circuit. She is the owner and founder of the Bongine Law Group, PLLC, with offices in New York, and then she gives the address in Illinois and gives that address. I submit this declaration in support of appellate's motion for an extension of time to file this opening brief pursuant to Local Circuit Rule 26 and Federal Rule of Appellate Procedure 26B. The Bongine Law Group is a boutique law firm comprised of myself, one managing partner, and one part-time paralegal. Undersigned counsel's firm has an extensive caseload of over 70 cases, with undersigned counsel predominantly responsible for the firm's appellate work. Specifically, undersigned counsel is responsible for digesting appellate's record, drafting the brief, and consulting with appellate prior to filing his opening brief. Due to undersigned counsel's engagement and other litigations, she is unable to complete appellate's brief by May 18th and is seeking a 45-day extension until July 3rd, 2023 to file his brief. 5. The professional obligations set forth below are not an exhaustive list of counsel's other obligations. However, those identified require a substantial amount of work and already have undersigned counsel working 80-hour work weeks at the present. These engagements have impacted undersigned's ability to turn her full attention to appellate's brief, which he surely is entitled to. 6. To be specific, undersigned counsel filed a 116-page opening brief in the United States Court of Appeals for the Second Circuit in United States versus Robert Sylvester Kelly. Then she gives the case information consolidated in April 19, 2023. That appeal stems from Mr. Kelly's September 27, 2021 convictions for racketeering and multiple Mann Act violations following a 6-week jury trial in the Eastern District of New York. United States of America versus Kelly, and then she gives the case number. Undersigned counsel was fully consumed with that opening brief for several weeks. 7th, on April 27, 2023, undersigned people had a continued post-conviction evidentiary hearing in the matter of People versus Michael Samantha. This case stems from a reversal and remand from the Illinois Appellate Court, which was issued on September 4th, 2020. Then 8, on April 28th, 2023, undersigned counsel had a 7-hour deposition of plaintiff's police practice expert in Masonnet versus Guevara, which also required several hours of preparation prior to the deposition. The lawsuit derives from a 1990 arrest and conviction of Mr. Masonnet, who served 27 years for a double murder he did not commit. Number 9, on May 1st, 2023, undersigned counsel had a motion to dismiss plaintiff's complaint in Bernard, etc. versus Cosby. Let's see, in New York Supreme Civil Court. Today on May 5th, 2023, I think it's. I'm just looking at, Lord, this lady is busy. And she says she only got two other lawyers that are paralegal working with her. Girl, you need to put a help wanted ad out. So it says today, on May 5th, 2023, which is yesterday when she submitted this, undersigned counsel has to file another motion to dismiss plaintiff's complaint in Pinkerton versus Cosby, which is also being heard in New York Supreme Civil Court. Both of these lawsuits stem from decades-old allegations of sexual misconduct from the late 1980s and early 1990s. 10. Between May 10th, 2023 and May 17th, 2023, undersigned counsel has 4 depositions in the matter of Ochoa versus Lopez, which was heard in the Northern District of Illinois, which cannot be rescheduled as there is an impending fact discovery deadline of June 30th, 2023 in that matter. 11. On June 7th, 2023, undersigned counsel has an opening brief due in the 8th Circuit of Appeals in the United States versus James Timothy Norman. Child, y'all know that's Tim from... Now, Jennifer, you can drop Tim case, child. I don't even know why you wasting your time on that one, but hey, stranger things have happened. So y'all, on June 7th, she got to present her opening brief, okay, for Tim. And it says a direct appeal which stems from September 16th, 2022 conviction for conspiracy to commit murder for hire. A 9-day jury murder for hire, and conspiracy to commit mail or wire fraud following a 9-day jury trial. Child. Okay, so 12, finally. On June 8th, 2023, undersigned counsel has an opening brief due in this court in the matter of United States versus Sean Baldwin. Mr. Baldwin was convicted on February 26, 2019, following a 3-week trial on 8 counts of fraud. He was sentenced on October 18, 2021 to 204 months on each count, with all terms to run concurrently. His direct appeal was stayed pending retention of counsel. Undersigned counsel filed her appearance on March 22, 2023, and is presently prioritizing that deadline. 13. Furthermore, and most importantly, Mr. Kelly was transferred from the Metropolitan Correctional Center in Chicago, Illinois, to FCI Butner in North Carolina on or around April 24, 2023. Undersigned counsel has limited access to Mr. Kelly and is unable to meaningfully consult with him before the current May 18th deadline. Furthermore, Mr. Kelly is functionally illiterate, so counsel must confer with Mr. Kelly in person for extended periods of time to read and review each of the filings submitted on his behalf. This proves even more difficult where undersigned counsel resides in New York, while Mr. Kelly is now in North Carolina. Granting undersigned counsel's motion for an extension will give her the opportunity to visit Mr. Kelly and have meaningful discussions with him regarding his pending appeal. 14. The Sixth Amendment guarantees a criminal defendant the right to effective assistance of counsel on his first appeal as of right. Vineyard versus United States, which was a case heard in the 7th Circuit in 2016, as the United States Supreme Court has held, the need for forceful advocacy does not come to an abrupt halt as the legal proceeding moved from the trial to appellate stage. Both stages of the prosecution, although perhaps involving unique legal skills, require careful advocacy to ensure that rights are not foregone, and that substantial legal and factual arguments are not inadvertently passed over. And that was from Pinson versus Ohio, which was a case heard in 1988. 15. With these principles in mind, undersigned counsel needs adequate time to consult with Mr. Kelly in order to competently represent him on direct appeal. 16. The government has no objection to Mr. Kelly's extension request. 17. For the reasons set forth above, undersigned counsel seeks a 45-day extension of time until July 3rd, 2023 to file his opening brief in this matter. Pursuant to Title 18 United States Code Section 1746, I declare under penalty of perjury that the foregoing is true and correct. And this was executed on May 5th, 2023. Now, we appreciate everything that you are doing, but girl, you're doing too much, okay? You just got too much on your plate. You better slow down and take care of yourself. Because, so she's still handling all the Bill Cosby cases. She has several Chicago cases where they're working to get these people's sentences overturned and stuff. And then it was announced that in the past few days that she has now taken on the appeal of Harvey Weinstein. So she has a lot on her plate, okay? What's his name? Harry Lindenweber. He did approve that and gave her until July 3rd in order to file the brief in the Northern District of Illinois. So guys, that's it for what's going on in the civil cases and the update to the Northern District of Illinois and her filing an appeal in that case. Go ahead, leave your comments below, and then later on today I will bring you part 3 of the email readings. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.